Very warm welcome to my channel, dear viewers. Today we will discuss one remedy under the Specific Relief Act, which is injunction. Injunction means an order. When we are speaking in legal terms, it means an order of the court. So an order of the court means an injunctive order, injunction. Injunction actually is a very important remedy which redresses a lot of wrongs, which actually stops a lot of wrongs, which has the ability to even stop or to restrain an anticipated thing which is going to happen, which prima facie exists in light of the record. If you can show to the court that there is a possibility of infringement of your right, or an possibility that your right has been would be taken away illegally and unlawfully, and if you address to the court and you invoke this remedy of injunction, then court is there to help you with this remedy at two stages of a suit. At one stage, at the very start, it can give you the temporary injunction, and at the end, if you win the case, it will be converted into a permanent injunction. So today we are not going to discuss permanent injunction. Actually, we are going to discuss the first part of it, which is temporary injunction, which is granted at the start of the suit. This injunction is applied in the form of an application under the CPC, Code of Civil Procedure 1908, Order 39, Rule 1-2, which says that if you provide court with three things, and those three things are: number one is prima facie case. You have to establish in light of record, in light of the statements of the witnesses, or in light of the available record at that time which you have at the start of the suit, and documentary evidence, your title documents. If you can present that before the court and court is satisfied that yet prima facie in light of the documents it seems that this person seems to be the owner, or this person seems to have title, a valid title, then the court actually starts hearing your case with more interest. And secondly, if you can tell to the court that not only the prima facie arguable case is in my favor, but also if this injunction is not provided to me, I will suffer a loss which will not be calculatable or countable in the terms of money, which means that it would be an irreparable loss, like loss to goodwill, like loss of privacy, like loss of something which affects you and cannot be converted into monetary terms. Thirdly, you have to show to the court that balance of inconvenience also lies in your favor. That if court weighs both sides of the case, your case and the opponent's case, then you will be at more inconvenience that if injunction is not granted. You will suffer more inconvenience as compared to the other party if the injunction is not granted. So when you present these three things in your application, that prima facie good arguable case is in your favor, number one, you will face irreparable loss, number two, and balance of inconvenience is actually lies in your favor as compared to the other party. If the court is satisfied, then the court gives you or grants you the injunction at the start of the suit against an application filed under Order 39, Rule 1-2, and this injunction will be called as temporary injunction. After the trial of the case, if the court is satisfied that the temporary injunction granted at the start of the suit was correct, then it will be converted into permanent one, which will be called as permanent injunction. Thank you very much.